Hey everyone, welcome to another episode on the Patti Martin Real Estate Group YouTube channel and podcast. We have a special guest with us today who's well-versed in real estate law. I want to welcome Eric Schroter. How you doing, Eric?
I'm fine, thank you, Adam.
Wonderful. How long you been in law? What can you tell the audience about yourself?
Well, I've been practicing law for, believe it or not, 35 years now. 33 of it in Richmond. I'm with the firm of Campbell, Fromay and Rice, who has been here even longer than I have, and I'm practicing mainly now in the areas of estate planning, tax and succession planning. Just a natural evolution of my work.
And Eric, one of the reasons we asked you to participate today is we are doing a series of podcasts on how people can help their children buy in today's real estate market. And you were almost the impetus for this podcast because one of our mutual clients came back and said, Eric came up with this great idea. And I was like, that is a great idea. We need to share that. So we're hoping to do that today. Can I just start, Adam?
Yeah, go ahead.
Yeah, I mean, we all wanted to help our kids, but we also want to protect our investments. So let's start with if your child is single. What would you do to protect any contribution you made to a purchase that they were going to undertake?
Well, just as a lead-in, I think probably the most important thing you can do for your child is protect that money that you're going to lend them. For a lot of families, it's a one-time thing. You know, if you have a certain amount set aside that you know you're going to help your child buy a house or any other major purchase, you most often don't have it a second time. So if they lose it through to creditors, a bad relationship, you know, their chance to own may be gone. Mm-hmm. So if I have a single child and I'm going to help them with a down payment on a house, I'm going to recommend that it's structured as a loan. So I'm not giving them the money. It's not a gift. I loan it to them. That loan is evidenced by a promissory note, which is just usually a one-page document that evidences how much money was loaned and on what date. And we'll usually secure that by a mortgage that could, if necessary, be registered against the property. So those documents are all signed in advance. So there's the loan is properly evidenced, and then we can decide based on a number of factors whether we're going to actually register this mortgage on title to help secure it.
So we actually talked to a mortgage broker today, and we talked about just this, whether you go on title, whether or not the mortgage is registered. But even just with the promissory note, you're okay? Do you feel that?
The promissory note is certainly better than nothing, but the reason I like to have the mortgage because it allows us, if the time, depending on the lender's requirements and what's going on in the life of the child, it does actually allow us to secure that note against the property to make sure if it's sold that the parents are either first in line if there's no institutional lender ahead of them, or second in line if they've got, say, one of the chartered bank loans. Yeah.
And that's if they're single. So let's say now they've signed the promissory note, you've registered I guess you're fine if they then take on a partner, if it's registered against the title.
Yeah, so if they're, often we see that the loan is happening because you are now in a relationship, whether it's common law or marriage, and you're helping the couple buy their first home. If the spouse is going to be on title, like both of them will be on title to the property, then they both have to sign the promissory note. If you're lending money to your child and they're the only one on title, then only your child has to sign it. But for most people now, when they're getting advice, you know, standard estate planning advice these days is, well, you should be on property as joint tenants. So if one of you passes, the property will pass to the surviving joint tenant. So you have to make sure you're working with both of those kind of planning strategies.
Okay. Eric, what do you see as more advantageous, like a gift with restrictions or adding yourself to the mortgage or to title?
Well, it's certainly, well, you don't want to be on title as a parent in most cases. I work hard to avoid that for a number of reasons. It complicates the title. In theory, if a parent has any interest, there's capital gains tax payable on that interest. Now, a lot of people do just 1%, but if you're the true owner of that 1%, you're going to have to pay capital gains. It's not a large amount, but it just complicates the reporting. Also, if it's just your child or a couple that are on title with the parent, if the people on title pass, now you have to probate to get that 1% off, transferred over to the estate of the deceased. So there's a lot of complications, but having that 1% interest is just, and usually it's never necessary, but sometimes the banks will require it because they loan money based on income tests. So if your child doesn't meet the income test, they want your parent on title so that they can include their income in the calculation. Historically, they never did that. Mom and dad, or just one of them, parents, came on and signed as a guarantor. But for some reason, the banks all decided they didn't like guarantees. They were too easy to court challenge. So they decided, no, if we're going to include your income, then you have to be on title. So that's made for a lot of difficulties. So if you can do it, stay off title and structure the amount being advanced as a loan. And if you have to be on title, you're still going to do the same thing. You're still going to take the money advanced by you, still going to be a loan secured by a mortgage, but in nowhere in there should the money be a gift.
Okay, interesting.
So we've had cases, we've had a lot of success with this strategy, countless times where couple are separating, getting divorced, and the one spouse who's not the child, who is rubbing their hands thinking, I get half the equity. And we've even had the emails from lawyers saying, okay, my client wants to be bought out of his half. Well, his half is what's left over the first mortgage and the loan to the parents. And usually that amount is quite a small amount at the end of the day for most properties. Now, we used to make sure it was zero because we used to set up these promissory notes and we'd add an interest rate to them. So mom and dad are loaning to their children, say it's $100,000, but interest at 8%, and we could always justify a higher rate because it was usually a second mortgage. But Revenue Canada decided that no, if you have a promissory note that has interest attached to it, then we're going to charge you each year on the interest, even though you never collect it.
Wow.
Because they say, well, you could demand the interest, even though you've chosen to forego payments, including the interest payments every year, you could insist on it. So we're going to say that it's income. So we stopped doing income on these promissory notes and just saying it's a loan without interest.
Right. And in the case of the client I was talking about, you suggested they have a no interest loan, right? Is that right?
Yes.
And in their minds, they will never collect on it unless there's a problem within the marriage, correct? Is that the idea? So that they're really not trying to step in the way. They're trying to give the money to the kids, but by doing this, they protect if something went wrong with the marriage.
That's correct. So they're not planning to demand it, and often they will deal with forgiving the loan or equalizing on the loan in their wills.
I see. So it would be that far down the road.
Yes, because even though the most common reason for structuring the money being advanced as a loan is marital breakdown, it could also be creditor problems. It could be an insolvency in the person's work. A person could fall into substance abuse. I mean, there's a lot of other things that could affect that equity, right? And so if structured properly, it's not a problem. We had one situation where, the parent wasn't in good health, and they knew they weren't going to survive their children, and the marriage was already rocky. So they didn't want to forgive the note in their will. So what they did is they gifted the note to a third party. In this case, the brother of the person who advanced, the parent, or the uncle, being the uncle of the child, right? So now he held the same note and the same and he could give it to his, in this case, his nephew when he died, but they knew they could extend this whole protection of the money farther down the road by having a different family member hold the note.
Wow.
Yeah. So there's lots of planning that can go on.
Yeah, and there's lots of ways to make sure you're not caught.
Yes, that's right.
Giving money to someone you no longer care about.
Yeah, so what usually happens, and we've done this many times, is, the couple separate, the homes get sold, the money comes back into our trust account on the sale, and then immediately a week later we're re-advancing it for the new home for the child. And we're setting up a new promissory note and a new mortgage on the new property they're buying by themselves.
Nice. So are there any tax implications to the parents? Like what would they worry about? Anything that they have to worry about other than?
No, like I said, their biggest tax issue around this whole structure would be if you wanted to charge interest. Then some people still do, but they're running a risk of being audited on it and being charged income tax on the interest they could have collected. So from a tax perspective, I think that's the only real issue. On an estate planning issue, it's just make sure that you've properly set out the loan and it's properly evidenced for your will purpose as well, so that if you have multiple children, that you make sure that the other children aren't being disadvantaged.
Got it.
What about like property transfer tax or speculation tax or empty homes tax or the other new tax from CRA, which is the underused housing tax? How do you kind of walk parents through what their obligations might be on this side of the equation?
Well, none of those taxes will affect the parents as long as they're not on title, right? If you can be a charge holder on the property. But if the bank insists that they go on as a 1%, at the very least, they're going to have to be making their speculation of vacancy tax declaration every year with respect to that 1%. If you happen to live in Vancouver, you have to make your declaration for empty homes tax as well. If you're a Canadian resident and or Canadian citizen, you're going to be avoid the federal underused housing tax declaration. That's a very rare, and you get separate advice, usually from your accountant on that. But for the BC taxes, it's only going to affect the parents if they're actually on title.
And your advice, again, is, I just want to reiterate this, don't go on title unless they need you for qualification purposes. Otherwise, there's no need. You're not any better advantaged either way.
No, you're not better protected. So
yeah, okay. That's great information. Yeah, thank you. I really appreciate that.
Awesome. I think that's a lot of information on how to set yourself up so you can help your child purchase real estate and protect your involvement in your asset as well. Eric, if anybody wants to get a hold of you, of course they can contact us and we can help put them in touch with you. Is there any other way our audience and our database can get in touch with you?
Well, all you would have to do is Google my name, and it would come up as a lawyer in Richmond, and her website, and all my contact and my bio, and a picture of me that looks a little bit younger than I do now.
Don't we all? Don't we all have those pictures? Thank you so much, Eric, because it's such a great way to help your kids, but it's also really important. Like, this is the one thing we always want to talk about when everyone's getting along, is how to make sure that everyone understands who the gift was for and why. And it's a conversation that if they come to you as parents, and they can take to their kids, they can say the lawyer said, and then they're not the bad guy, and everybody's protected, which is a beautiful, beautiful thing, because if things go sideways, it can never be pretty if these things aren't attended to early on. Yeah.
I agree with you completely.
Yeah.
Well, thank you so much for having me on your podcast. It was a pleasure joining you, and maybe we'll do it again one day.
Yeah, thank you, Eric. Take care.
Okay. Thanks a lot.
Thanks, guys.